Hello, and welcome to our module on corporate laws and practice, where we'll explore the fundamentals of the Insolvency and Bankruptcy Code of 2016. Let's dive into the fundamentals of the Insolvency and Bankruptcy Code, or IBC, enacted in 2016. It's called a code because it consolidates many existing laws into a single, comprehensive framework for insolvency and bankruptcy. The IBC was introduced to streamline proceedings, provide a time-bound resolution for financial distress in both individuals and companies, and achieve key objectives like maximizing asset value, promoting entrepreneurship, and balancing the interests of all stakeholders. To understand the IBC, it helps to look at its historical context. India has a long history of insolvency laws dating back to the 1800s. However, before the IBC, the landscape was fragmented, governed by multiple separate legislations. These included specific provisions within the Companies Act of both 1956 and 2013, the Sikh Industrial Companies Act, often called SICA, from 1985, and other acts like the Recovery of Debts Due to Banks and Financial Institutions Act, and the SAR-FAESI Act, dating from 1993 and 2002 respectively. These previous legislations faced significant problems that necessitated the IBC. For instance, SICA was often unsuccessful and misused, sometimes shielding debtors rather than providing genuine rehabilitation, leading to cases pending for more than 20 years without lasting relief. Other acts like the RDDBFI and SAR-FAESI had limited scope, assisting mainly banks and financial institutions, and lacked mechanisms for broader restructuring or dissolution. SAR-FAESI, specifically, was only applicable to secured debts. Furthermore, the Companies Act applied only to companies, leaving out individuals and partnership firms. Overall, there was a critical lack of a single, consolidated law, which led to significant delays in resolving insolvency cases. Recognizing these issues, the Ministry of Finance instituted the Bankruptcy Legislative Reforms Committee in 2014, which recommended a single and comprehensive framework for insolvency laws, ultimately leading to the IBC 2016. The IBC brought about a significant paradigm shift with several key objectives. Its primary aim is to streamline proceedings and provide a time-bound mechanism for resolution, while maximizing the value of assets. It also seeks to promote entrepreneurship, fostering a business-friendly environment, and ensuring fairness by balancing the interests of all parties involved. Ultimately, the goal is to revive companies and help them stand on their feet, with liquidation being considered only as a last resort, thereby ensuring efficient recovery for creditors. This represents a major shift from a debtor-in-possession model, where the debtor previously controlled the process, to a in-control model. So who does the IBC apply to? While it primarily covers corporate persons, the code also extends to individual and partnership insolvencies, providing a comprehensive framework under one umbrella legislation. A crucial trigger point for a company to come under the IBC is the occurrence of default. Section 4 of the code initially stated that the minimum amount of default must be at least 1 lakh rupees. However, the central government has the power to increase this minimum threshold, and indeed, on March 23, 2020, it was increased significantly to 1 crore rupees. Now, let's look at the overview of the Corporate Insolvency Resolution Process, or CIRP. It broadly moves through 4 key stages. First, the occurrence of financial default by the corporate entity. Second, the initiation of the CIRP. Third, the admission or rejection of the application by the National Company Law Tribunal. And finally, the formal commencement of the CIRP itself. Stage 1 is simply the occurrence of default, when a company fails to pay its debts. Stage 2 is the initiation of the CIRP, and this can be done by a few key parties. First, a financial creditor, which is a person or entity to whom a financial debt is owed, like a bank or a large financial institution. They file an application under Section 7, and crucially, they must mandatorily propose the name of an interim resolution professional, or IRP, and prove the existence of default with evidence. Next, an operational creditor, typically a supplier or a trade creditor, to whom an operational debt is owed. Before filing an application under Section 9, they are required to follow 3 steps. First, deliver a demand notice to the corporate debtor. Then, they wait 10 days for the corporate debtor to respond, either by proving a dispute or making payment. If there's no satisfactory response, they can then file their application, providing a copy of the invoice, an affidavit stating the non-existence of a dispute, and proof of default. They may or may not propose the IRP's name. Lastly, the corporate applicant, meaning the corporate debtor itself, can also initiate the process. They file an application under Section 10, which requires a special resolution passed by its shareholders or 3/4 of its members if it's a firm. Like financial creditors, they must also propose the name of an IRP and prove the existence of default. Moving to Stage 3, admission or rejection by the adjudicating authority. For corporate persons, this is the National Company Law Tribunal, or NCLT, while for individuals, it's the Debt Recovery Tribunal, or DRT. When an application is filed, the NCLT assesses its completeness based on 4 key aspects. Is the application complete in all respects, with all required documents furnished? Is the existence of default clearly supported by submitted evidence? If an interim resolution professional is proposed, the authority must verify with the Insolvency and Bankruptcy Board of India, or IBBI, that no disciplinary proceedings are pending against them. This verification is compulsory for financial creditors and corporate applicants, and optional for operational creditors if they propose one. Lastly, for applications filed by an operational creditor only, an affidavit must be submitted stating the non-existence of any dispute with the corporate debtor. If these 4 aspects are present and complete, the adjudicating authority must admit the application and cannot reject it on any other grounds. Stage 4 marks the formal commencement of CIRP, kicking off with several key milestones. Day 0, the insolvency commencement date, is the day the application is admitted by the adjudicating authority. On this very day, the Interim Resolution Professional, or IRP, is appointed, and a moratorium is declared on the assets of the corporate debtor, essentially pausing legal actions against them. By day 3, a public announcement is made in an English and a local language newspaper to invite claims from all parties who are owed money by the corporate debtor. Claims can generally be submitted by day 14, although later submissions can be condoned. Then, by day 21, the IRP verifies all submitted claims, typically within 7 days of the last submission. Following verification, the IRP constitutes the Committee of Creditors, or COC. It's important to note that the COC is comprised solely of financial creditors. Finally, by day 30, the first meeting of the Committee of Creditors should be held. In this crucial meeting, the COC decides on the appointment of the Resolution Professional, or RP, either continuing with the existing IRP or replacing them. Let's quickly recap the key players involved in the CIRP. We have the corporate debtor, the company facing insolvency, and the creditors, divided into financial creditors like banks and financial institutions, and operational creditors like suppliers and employees. The adjudicating authority for companies is the NCLT. The Interim Resolution Professional, or IRP, is appointed initially to manage the debtor's affairs and form the COC. The Resolution Professional, or RP, takes over, managing the debtor's affairs and evaluating resolution plans. The Committee of Creditors, or COC, consisting of financial creditors, is central to evaluating and approving resolution plans. And finally, the Insolvency and Bankruptcy Board of India, or IBBI, is the regulatory body that oversees and monitors the insolvency process and regulates professionals. Regarding timelines, the entire CIRP process is mandated to be completed within 180 days from the insolvency commencement date. This period can be extended by the adjudicating authority for a maximum of 90 days, bringing the total possible duration to 270 days. Furthermore, the Supreme Court has mandated an overall maximum timeline of 330 days for the completion of the CIRP, which includes any extensions and even time spent in legal proceedings. Finally, let's clarify 3 often confused terms: insolvency, bankruptcy, and liquidation. Insolvency simply refers to a financial state where a person or company is unable to pay their debts when they fall due. It's the condition of financial distress. Bankruptcy, on the other hand, is a legal status declared by a court, typically for individuals, formally deeming them unable to repay their debts. Liquidation is the process of winding up or dissolving a company. This occurs if no viable resolution plan is approved within the prescribed CIRP timeline. In such a scenario, a liquidator is appointed to sell the company's assets and use the proceeds to pay off its outstanding debts to creditors. Thank you for joining this session. Hello, and welcome.